Welcome. It's wonderful to be here for this Friday afternoon panel on impeachment. Thanks very much to Mike for organizing this wonderful conference and this amazing panel. Many experts believed impeachment was the appropriate remedy to rein in what they perceived as former President Trump's abuses of powers and threat to the Constitution, as well as potentially permanently disqualify him from holding office. And as we know, several Republicans have made moves in the House. There's kind of action on this day to day with different reasons being given to consider impeaching President Biden. Yet the last three impeachments of Bill Clinton and both Trump impeachments ended in acquittals. And so today we're going to be talking about, did those impeachments accomplish anything? Did they do damage to anything? Should impeachment be seen as a regular part of the congressional arsenal for checking the presidency, which is what some political historians, well, they've not argued it should be, but that it has become such. Or should it be reserved for extraordinary events? And if it is for extraordinary events, how are we going to define them? So I'm thrilled to introduce our panel who's going to be grappling with these issues. I'll introduce each of them now, and then we'll allow each of them to deliver their prepared remarks, leaving hopefully a half hour for your questions to them. First, Philip Bobbitt is the Herbert Wechsler Professor of Jurisprudence at Columbia Law School and Senior Fellow at the Strauss Center for International Security at the University of Texas. He has served in a number of capacities in the US government and has published 10 books, including Tragic Choices, Constitutional Fate, Constitutional Interpretation, The Shield of Achilles, War, Peace, and the Course of History, and Terror and Consent. He is a fellow of the American Academy of Arts and Sciences and the Royal Historical Society. I'll note he is a Knight of the British Empire, so I guess I should have said Sir Philip Bobbitt. And he has been a trustee of Princeton University as well. In alphabetical order, though this isn't the order in which we'll speak, next we have Noah Feldman, who's the Felix Frankfurter Professor of Law, also chairman of the Society of Fellows and founding director of the Julis Rabinovitz Program on Jewish and Israeli law, all at Harvard University. He specializes in constitutional studies with particular emphasis on power and ethics, design of innovative governance solutions, law and religion, and the history of legal ideas. Many of you may know that Noah's a columnist for Bloomberg Opinion. He also writes for the New York Review of Books, and for 10 years, for nearly 10 years, was a contributing writer for the New York Times Magazine. He hosts the Deep Background podcast, which is a great interview show that explores the historical, scientific, legal, and cultural context behind some of the largest stories in our news today. He is also the author of 10 books, like Philip, including 2 textbooks, Constitutional Law, which is in its 21st edition, and First Amendment Law in its 8th edition, both with Foundation Press, and his latest title, To Be a Jew Today, A New Guide to God, Israel, and the Jewish People, was released on March 5th of this year. Pamela Karlan, I think no one really needs an introduction here, but hopefully since she's at Stanford, she really needs no introduction. But even so, she is the Kenneth and Harl Montgomery Professor of Public Interest Law here at Stanford, and she's co-director of the school's Supreme Court Litigation Clinic, where, as many of you know, students litigate live cases before the court. She's one of the nation's leading experts on voting and the political process, having served as a commissioner on the California Fair Political Practices Commission. She's also been an assistant counsel and cooperating attorney for the NAACP Legal Defense Fund, and twice was a deputy assistant attorney general in the Civil Rights Division of the US Department of Justice. There, she won the department's highest award for employee performance, the Attorney General's Award for Exceptional Service, as part of the team responsible for implementing the Supreme Court's decision in United States v. Windsor. She's the co-author of leading case books on constitutional law, constitutional litigation, and the law of democracy, as well as numerous scholarly articles. And she's currently a co-reporter on the American Law Institute's forthcoming reinstatement on constitutional torts. John McGinnis can't be with us, unfortunately, in person, so he's going to be zooming in. He is the George C. Dix Professor in Constitutional Law at the Pritzker School of Law at Northwestern University. He's the author of Accelerating Democracy, Transforming Government Through Technology, and Originalism and the Good Constitution. He's the past winner of the Paul Bader Award, which is given by the Federalist Society to an outstanding academic under 40, and he has been listed by the United States on the roster of panelists who may be called upon to decide World Trade Organization disputes. John is a graduate of Harvard College and Harvard Law School, where he was editor of the Harvard Law Review. He also has a master's from Balliol College, Oxford, in philosophy and theology. He clerked on the U.S. Court of Appeals for the District of Columbia and was also Deputy Assistant Attorney General in the Office of Legal Counsel at the Department of Justice back in the George H.W. Bush at the end of at the George H.W. Bush presidency and part of the Reagan presidency from 1987 to 1991. Thanks so much, John, for zooming in, and I'm going to now turn it over to our outstanding panelists. Thanks, Philip, for leading us off.
Thank you. The title of my topic today is Impeachment, the Canary in the Constitutional Coal Mine. It's become commonplace to say that we are governed by 18th century framers and their constitutional culture. Commonplace, but far from true. My wife gave me a signed engraving of Benjamin Franklin at the French court that hangs in our apartment in New York. Franklin is surrounded by adoring aristocratic women and jealous courtiers. That much I see, perhaps as Franklin himself might have seen. The envious glance, the carefully placed glove, but that's about all. And I see things that few of the subjects in the engraving could have seen, that in 20 years, it would all be gone. Art is as we are. We can't separate ourselves from our situation or our appreciation. So I must conclude that though this is maybe a disturbing fact, the Constitution is as we are. That may not today be much of a compliment. Nowhere is this more obvious than with respect to impeachment. The text and historical scholarship have been stable for more than 2 centuries. Their changing appreciation provides a guide as to where we're going with other parts of the Constitution, which is to say a guide as to what is at present a deep challenge to the constitutional order. As all of you are aware, and has been observed in the last panel, for almost 2 centuries of our constitutional life, there was only one presidential impeachment. During our country's first 44 presidencies, there were only 2 episodes of presidential impeachment. The next 4 presidents saw 3 impeachments, all of them frustrated in the Senate. John Quincy Adams had refused to bring a vote of impeachment against President John Tyler because he believed that he couldn't get a Senate conviction, though he had the votes in the House. Today, the prospects for Senate conviction do not appear to faze those pressing for the impeachment of President Biden or those who won an absurd impeachment vote against Secretary Mayorkas. We are now more inclined to treat impeachment as a political struggle for public opinion, waged in the media, and less like the grand inquest envisioned by the Constitution's framers. Moreover, it has been repeated so often that it is now taken for granted that impeachment is not a legal matter, but a political one, an observation that is heedless of the loss of legitimacy incurred when legality is pushed aside. But this insidious apophthegm does reflect the changing nature of public opinion and its role with respect to the legitimacy of our constitutional institutions. Currently, the House Oversight and Judiciary Committees say they will bring contempt proceedings against the Attorney General, Merrick Garland, over his refusal to provide tapes of the special counsel's interview of President Biden. Why? To determine, in the words of Congressman Chip Roy, quote, where we are going with our impeachment inquiry, end quote. I take this to mean where we can go with our impeachment inquiry. It reminds me of Congressman Bob Barr's first act as a member of the House of Representatives. He filed a bill of impeachment against President Clinton without stating any charges. He said, we'll fill those in later. To these distressing developments must be added the increasing importance of impeachment as a fundraising tool. Not only has the pace and character of impeachment changed, but also the constitutional grounds and the scope of liability to impeachment. The Constitution is, of course, quite specific with respect to the grounds for impeachment. These must be constitutional crimes that strike at the very foundations of our institutions. Limiting the grounds for impeachment to treason, bribery, and similar dread offenses was a significant turning point at the convention, away from parliamentary supremacy and toward putting the state under law. The trial of President Clinton was a notable diversion from these rules. Second, the Constitution is also quite clear as to the scope of liability. Only a civil officer can be impeached, tried, and convicted. Thus, the Senate trial of the former president, Donald Trump, was a further indication of a departure from the most explicit text and historical commentary. When Donald Trump in 2016 proposed that Hillary Clinton be impeached so as to remove her from the ballot, he was ridiculed since she was no longer in office. Now it has been said by very competent scholars that even dead people can be impeached by the House and tried and convicted by the Senate. Thus, the disregard of the grounds for impeachment in the Clinton and Mayorkas cases, the for what provisions of the Constitution, and the disregard of the scope of liability in the Senate's second trial of Donald Trump, blurring who can be impeached, represent significant developments in a turn away from law. Finally, there is the change in the juridical function of the Senate at an impeachment trial. Senators now say how they will vote before the trial has commenced, and votes routinely break sharply along political lines of party. I think the implications of these developments for the Constitution as a whole are profound. When President Nixon was facing impeachment, there was almost no scholarship on the subject. It was very much a peripheral subject. There was just one much criticized book. Now, it is a harbinger, I believe, of the transition from the constitutional order of industrial nation states to a new order that some have called the informational market state. Market states reduce the dependence of the state on law and on the regulation of markets with methods of direct democracy and an increased reliance on markets and private actors. When states move from conscription to an all-volunteer force, when they outlaw affirmative action, when they move from state-owned enterprises like mines and energy, trains, and air forces, that is, commercial air forces, to sovereign wealth funds, when they forbid the regulation of sexual practices, when they outsource police and military functions to private corporations. In all these, we are seeing the emergence of the informational market state. This will place even greater emphasis on political polling and the popularity of Supreme Court decisions, the tools of marketing. In his 1962 dissent in Baker versus Carr, Justice Frankfurter slightly changed Alexander Hamilton's famous remark in number 78 of the Federalist Papers. Frankfurter wrote that, quote, "The court's authority, possessed of neither purse nor the sword, ultimately rests on sustained public confidence," end quote. But of course, that's not quite what Hamilton said. Hamilton said that the court's authority rested on its judgment, not on its popularity. It may be a coincidence that the invention of accurate mass public opinion polls began to have an impact on politics at about the time FDR was confronting the Supreme Court over New Deal legislation. But its real influence on our concept of judicial legitimacy occurred decades later, when public opinion polls began to gauge the levels of public support for the court. Some of you may have seen, just last week, the New York Times summary of a list of the important Supreme Court decisions that will be handed down this term. After a 2 or 3 paragraph summary of the issues in each case, a poll was cited, done by the Times, indicating the percentage of persons who thought the case should come out one way or the other. For example, in Trump versus United States, the question was, do you think former presidents are immune from criminal prosecution? In the emergency abortion care case, the question was, do you think Idaho hospitals must provide abortions in medical emergencies? Or in the Rahimi case, do you think barring domestic abusers from possessing firearms violates their Second Amendment rights? None of these options are legal answers, and no opinion of the Supreme Court will, I trust, ever consist of a single sentence stating a question and then saying yes or no, the way the poll is framed. The current perception and practice of impeachments is of a piece with this view of legitimacy as a matter of public opinion, and it will, I believe, come even more frequently, more corruptly, and with greater irregularity. Like voter referenda, recall votes, legislative initiatives, and the like, it will become one more market state weapon deployed against the rule of law in our constitutional institutions. These developments may take us in the direction of parliamentary supremacy. That's the implication, I believe, of the current popularity of Thayerism. And this would be a considerable rebuke to our Constitution and its structure as originally proposed and adopted. But I think that is the most important aspect of what's happened to impeachment today. To summarize, the changes in the practice and perception of impeachment, I think, are quite ominous. Among other things, they cast a shadow on our willingness to follow the law even when we don't like the outcome, and move us in the direction of parliamentary votes of confidence. But not a show of hands of the public, nor of experts like the people at this conference, but careful reasoning about impeachment along the lines of classic legal argument is necessary, because only this, I believe, can give the true imprimatur of legality and thus a sustainable basis for constitutional legitimacy. Thanks.
So first of all, thanks so much to Michael for putting together the conference. Where did he go? He was over there. Yeah, there he is. And to Morgan, who has done saintly work in keeping us all moving forward. And it's also obviously a pleasure to be reunited with my impeachment buddy, Noah. And so glad that he's here. And then thanks to Philip as well for making it possible for me to spend the winter in Florence teaching students about Machiavelli. And I used his book On the Court and Palace so much in doing that. So it's really a pleasure to be here with them and to see so many friends and students of mine in the audience. So in 2006, Darrell Levinson and Rick Pildes published a wonderful article in the Harvard Law Review. It was titled Separation of Parties, Not Powers. Their thesis was that the founders' theory of branch-based separation of powers, where Congress and the president would mutually check one another, where ambition would counteract ambition, began to break down immediately with the emergence of political parties that had members in both branches of the government. And so Rick and Darrell argued that during a period of what they called cohesive and polarized political parties, competition and the checking of one branch by the other might well disappear if party control of the House, the Senate, and the presidency is unified. Today, I think we've moved another step past the world about which Darrell and Rick were writing. To quote the title of another wonderful work, this one by Norm Ornstein and Tom Mann, it's even worse than it looks. How the American constitutional system collided with the new politics of extremism. We now live in a world where Congress is far more polarized than any time since the late 19th century. According to a Pew Center analysis, 50 years ago, so basically on the eve of the impeachment of the events that led to the impeachment proceeding involving Richard Nixon, there were 144 House Republicans who were less conservative than the most conservative House Democrat, and 52 House Democrats who were less liberal than the most liberal Republican. So there was quite an overlap between the two parties ideologically and geographically and the like. Well, there's no longer any overlap. Since 2002, when two Republican representatives, Connie Morella of Maryland and Benjamin Gilman of New York retired and were defeated for re-election. There's been no overlap in the House at all between the most liberal Republican and the most conservative Democrat. And when it comes to the Senate, the end of that overlap occurred in 2004 when Democrat Zell Miller of Georgia retired. At the same time, I think it's also fair to say that at least with regard to the Republican Party, the party in office, to use V.O. Key's typology, is less cohesive and less disciplined than at any time in modern memory. Think about the debacles, in the plural, over the House speakership and the like. Now, also as a historical matter, the Democratic Party has become more ideologically coherent in a bunch of ways, in a sense that the New Deal coalition of a white supremacist southern wing and a more moderate and liberal group of northern and western wings crumbled in the 1960s. So what's the upshot of all of this? Why have I been telling you this in a panel that's about impeachment? The upshot of this is that the last time one party held at least 67 seats in the Senate was the 89th Congress from 1965 to 1967. Given the political geography of the current United States, it seems unlikely indeed that we will ever see a 67-seat majority again. And why does that matter for impeachment? Because that's how many votes you need in order to get a conviction. So in this world, the bottom line is that impeachment is simply not going to serve as any realistic part of the congressional arsenal for checking the presidency, in the words that are designed to describe this panel. Even when the Senate is held by the opposing party won't have sufficient numbers to convict based on its numbers alone. And few members of a president's party these days are likely to cross the aisle. So even the most egregious misconduct is unlikely to garner enough votes for a conviction. That knowledge, which is surely within the understanding of even those members of the Senate, and there is at least one right now who can't name all the branches of government, is likely to backwash into the behavior of the House, where, of course, at least up until this point, there is a swing back and forth in partisan control, and a simple majority vote is all that's required to get the impeachment process underway. So that fact, that understanding, is likely to turn impeachment, as Philip has kind of alluded to, into more of a performative gesture, where the House can launch purported impeachment inquiries, one after the next, against a president of the opposing party as essentially clickbait for its base. What makes me particularly unhappy about all of this is that it's been occurring at precisely the time that impeachment might be used to deal with one of the problems it was originally designed particularly to address. Our Constitution begins with the words, "we the people," for a reason. Our government derives all of its powers directly or indirectly from the great body of the people. And the way it's supposed to derive that power is through elections. Elections matter, both to the legitimacy of the government and to all our individual freedoms, because as the Supreme Court explained more than a century ago, voting is preservative of all rights. Among the most important constitutional provisions is a guarantee of periodic elections for the president, one every 4 years. And America has kept that promise for its entire history. It's done so even in wartime, which differentiates us from most of the other democracies in the world. Britain didn't have any elections during World War II. We had one during 1944. Even during the Civil War, we had an election where we got one of the great innovations that's now so controversial, which is vote by mail. That was when we had absentee ballots in order to keep the Union troops in the field and therefore assist in Lincoln's reelection, because otherwise you'd have to call the troops home, which would get him reelected, but would result in us losing the Civil War. So we have had elections every 4 years, and we have had a peaceful transfer of power repeatedly during that. But the framers of our Constitution recognized that elections alone couldn't guarantee that the United States would remain a republic which was dependent on the great body of the people. One of the key reasons for including an impeachment power was the risk that unscrupulous officials might try to rig the election process. At the Constitutional Convention, William Davey warned that unless the Constitution contained an impeachment provision, a president might, in his words, spare no efforts or means whatever to get himself reelected. And George Mason insisted that a president who procured his appointment in the first instance through improper and corrupt acts shouldn't escape punishment by repeating his guilt. Mason was the person responsible for adding high crimes and misdemeanors to the list of impeachable offenses. So we know that that list was designed to reach a president who tries to subvert an election, whether it's in the election that brought him to office or in an upcoming election where he seeks a second term. And yet, the Senate has twice showed itself utterly unwilling, faced with a president who tried to do exactly what Davey warned against, to do anything about it. Elections have, since virtually the time of the framing, been partisan affairs. But what's different today than it was, say, 20 years ago, is that the view of elections has become partisan. It's kind of a meta-partisanship in which the faith in the fairness of an election turns on its outcome, not on the process itself. This past weekend, for example, J.D. Vance declared about the upcoming election, if it's a free and fair election, I think every Republican will enthusiastically accept the results. That presupposes, knowing J.D. Vance as little as I do, but it presupposes that no election can be free and fair unless Republicans prevail, because there's no way that he will be enthusiastically accepting the results in November if Joe Biden wins. That kind of hyper or meta-partisanship dooms impeachment as a possible check on the executive branch, because it simultaneously decreases the likelihood that a senator will see a president of his own party as engaged in misconduct as that president seeks to bend the electoral process, and it decreases the likelihood that any member of the president's party will vote to convict him with regard to any form of mis- or malfeasance. Or, to quote William Butler Yeats, the best will lack all conviction, while the worst will be full of passionate intensity. Thank you.
John?
Thank you very much, and thanks to the Constitutional Law Center, and particularly thank you for allowing me to speak virtually. I was too ill to travel, but I hope I'm well enough to speak. We'll see. So my thesis is that prudence is as important as law in assessing presidential impeachments, even if the conduct of the action of the president meets the standard of objective misconduct and breach of Republican norms. The harder question for any impeachment is whether it, in fact, advances the health of the republic. Unsuccessful impeachments commanding only or largely partisan support increase political polarization and reduce state capacity, making it harder to solve the nation's problems, including its substantial fiscal and geopolitical ones. In short, the apparent trend to more presidential impeachments can be both perfectly legal and yet deeply unwise. First to the law, briefly. We haven't talked much about it. The Constitution states the president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Like other constitutional processes, impeachment responds to a particular problem of governance, in this case, how to end the tenure of an officer whose conduct has seriously undermined his fitness for service, posing an unacceptable risk to the republic. This purpose is evident from impeachment's design. First, the sole consequences from impeachment, removal from office and potential disqualification from future office, make little sense unless impeachment is aimed at removing unfit officials. The consequences of impeachment go just far enough and no further than to remove the threat to the republic. If impeachable offenses could be set out in a code, it would make more sense to give the responsibility for evaluating impeachments to the judiciary, the arbiter of cases under determinate rules. If, in contrast, the task of impeachment requires the evaluation of a range of offenses in relation to fitness for office, the logical place for such responsibility lies in Congress. As Alexander Hamilton noted in The Federalist, judging whether misconduct undermines the public trust and makes continued service an unacceptable risk to the republic requires inferences not readily reducible to fixed rules like criminal law. Thus, the provision includes the phrase high crimes and misdemeanors. I think, and this is a legal phrase, it historically connoted serious offenses of public officials against the republic, most importantly, breaches of fiduciary duties, including the duty to follow the law. It's true that locating the impeachment process in Congress then raises another problem of governance. the danger that impeachment may make civil officers dependent on the caprices of legislatures. But the structure for impeachment addresses this problem. The framers employed a phrase, high crimes and misdemeanors, which on its face refers to objective misconduct and not to political disagreement. The framers actually expressly rejected maladministration as a standard, but in keeping with the framers' doubts about the efficacy of mere parchment barriers, a substantial supermajority of one branch of the legislature must approve the removal of any officers. I think, and this I may have therefore some disagreement with Professor Bobbitt, that this may prevent impeachment from becoming acting as parliamentary supremacy, in some sense for the reasons Professor Karlan suggested. It's always rather difficult to get 2/3 of the Senate, and so I think that will continue to be a barrier to moving us to a more parliamentary style of government. That was a wise choice of the framers. Now, to try to emphasize that I don't think it's a problem of law as much as a problem of prudence, there have been a variety of arguments, legal arguments, against recent presidential impeachments that might be well and wise, but I don't think the legal arguments were really strong against the impeachments. I mean, for instance, President Clinton's defenders argued that because his conduct was personal, it was outside the ambit of the clause. It was claimed, for instance, that because treason and bribery are crimes requiring abuse of official power, all high crimes and misdemeanors must concern the abuse of a presidential power. But I think that's wrong as a matter of both text and purpose. An executive branch official could bribe a judge to receive favorable treatment in a personal civil case, litigated in his private capacity, and could be removed under the express language of the clause. Moreover, a simple distinction between an official's private and public capacity I don't think comports with the purpose of the clause, because offenses of a public man in his private capacity can undermine the public trust, as Clinton's perjury and obstruction of justice did. Bruce Ackerman also argued that it was illegal for a lame duck House, as the Republican House was at the time of Clinton's impeachment, to impeach a president. But there's no such limitation in the Constitution. In Trump's first impeachment, some argue that either his foreign policy discretion or the mixed motives attending his attempt to hold up aid to Ukraine precluded the claim that this act represented an abuse of power. But even if his motives were mixed, I think it was certainly open to the House to conclude that his motive of attacking his political opponents so predominated that it amounted to an abuse of power in the exercise of his discretion. Fiduciaries can be found to violate discretionary duties. If abuse of power is the but-for cause of an act, the act is impeachable. In Trump's second impeachment, some argue that the impeachment articles could be sent to the Senate, or the Senate could not proceed with a trial because the president had already left office. But I think the contemplated punishment of disqualification for future office provides a rationale for holding impeachments after a president has left office, and nothing in the text, I think, clearly precludes that possibility. That's the strongest of the arguments, but I still don't think it's a strong quite enough. Despite their failure as law, however, these claims might well affect the prudential judgment about the wisdom of bringing a particular impeachment. Just because presidential impeachments were legal, it does not follow they are wise. The Constitution does not provide that the president must be impeached for any high crime or misdemeanor they commit. Moreover, the House's rule resembles that of a prosecutor or a grand jury, suggesting it can consider matters of public interest before bringing an impeachment. Thus, it can weigh the likelihood of the benefits of impeachment, including the likelihood of conviction against any costs. The costs of presidential impeachment significantly include increasing political polarization and reducing state capacity. By impeaching a duly elected president, an impeachment may infuriate his supporters. This may lead to a cycle of partisan impeachments, harming Republican stability. Of course, that does not mean that impeachment should never be attempted. I think it's important to understand that sometimes impeachment can change the minds of a president's supporters, even his committed supporters, certainly his more independent-minded supporters. The 1970s were also very polarized times. I remember them, yet the impeachment movement against President Nixon ultimately attracted enough support to force him to resign. That was not, in some sense, a successful impeachment. He wasn't removed by impeachment, but he was removed under the shadow of impeachment. But the conduct that forced Nixon from office was both a crime under ordinary criminal law and one that went to the heart of American democracy, a cover-up, a burglary of the opposing party's headquarters. The contrast of Nixon impeachment with Clinton's and the first impeachment of Trump in its persuasive capacity, I think, is pretty stark. Clinton's perjury and obstruction, I think, were both crimes and violations of Republican norms. But as Arthur Schlesinger put it, gentlemen lie about sex. And though I must say I think the comparison of Clinton to a gentleman was a bit forced, the focus on sex predictably drowned out consideration of the cost of presidential perjury to our entire legal system. Trump's first impeachment, in contrast, didn't concern an ordinary crime, but more an abstract impeachable charge, abuse of power. And the evidence there was contested, at least whether there had been a quid pro quo between aid to Ukraine and information about Biden. Moreover, as I understand it, Ukraine did in fact receive the aid. Both the obscurity of what occurred and its limited effect made it easier for partisans to dismiss. Thus, both impeachments predictably accomplished little other than to stoke polarization. They didn't even weaken either president. The poll ratings of both presidents went up. Trump's second impeachment is more plausibly prudent. The charges were both closer to a crime, instigating a riot, that was easy to understand, also about reversing, as Professor Karlan has suggested, the results of a basic Republican norm, an election. The Democrats, I think it's important to understand, weren't really willing to take the time and build public support for impeachment because it would have cut into the time to enact their political program. That's perhaps understandable. Well, unlike other two recent impeachments, it gained the votes of a substantial number of senators from the impeached president's party. It still fell short of the requisite number. And it's unclear whether some of those voting for conviction would have gone on to vote for the only relevant penalty, disqualifying Trump from office. They might well have balked at preventing people from exercising their democratic choice. For instance, I think something that certainly influenced the court in Trump versus Anderson. Beyond polarization, it's likely that failed impeachments reduce state capacities to address pressing problems of the nation. Impeachments redirect parliamentary time, both of members of Congress and staff, more insidiously, as Professor Bobbitt mentioned. They help people raise campaign contributions. Politicians can preen and posture about it, and it allows them to sidestep other questions. In this, they are abetted by the media because impeachments possess a binary magic, attracting viewers, unlike the complexity of policy debates. And finally, given all too human propensities, a groundswell of grievance makes it harder for political actors to compromise, not only because of their raw feelings, but because of the incited passions of their supporters. Lest that concern seem abstract, both Democrat and Republican members of Congress agree that the impeachment of Clinton scuttled ongoing talks about Social Security reform. Given the dire fiscal trajectory of entitlements that has resulted from doing nothing, this is a huge cost to the Republic. It's harder to point to a specific policy foregone, was the first Trump impeachment, but distrust among the parties has made it harder to unite even around matters of foreign policy like Ukraine, which often commanded bipartisanship. It's sometimes said that these various impeachments were needed to protect democracy, but impeachments that increase partisanship and polarization undermine the functioning of democracy. What Machiavelli said of killing the king applies to impeachments. It can be bad for the nation if you miss. Constitutional liberal democracy may be the best system of government, but it has signal weaknesses: limited bandwidth, limited capacity of a rationally ignorant electorate, and tribalism. Impeachments can exacerbate all these structural defects. Worse still, it brings to the fore all of the latent, what I would call the latent friend and enemy axis in politics. Sound republicanism at its best tries to tamp down rather than ramp up such a destructive distemper. So Professor Bobbitt and Professor Karlan suggested some reasons that we're in this world of perhaps ineffective and perhaps damaging, in some cases, impeachments. I'd like to add some others as well. I think this is part of a more general trend that we have seen. We not only see partisan impeachments, we see members of Congress spending their time censuring one another of both parties in performative politics. We see, on the other hand, an absence in government for a very long time for Congress willing actually to get down to the details of legislation, but to delegate large amounts of power to the executive branch. I see the greater danger is executive administration than parliamentary democracy coming, and I don't think impeachments are really going to change this. But one can see why this might happen, because this is rational for members of Congress. The questions of climate change, of how to have the tax code, they're always very complicated questions that are difficult, and that the future may show that members of Congress have made miscalculations. And so it makes sense, I think, for members of Congress who want to be rational about a re-election to move in this direction, particularly in a world when we have such a large state and when the questions, therefore, are so complicated that a rationally ignorant electorate, who really has many other things to do, doesn't want to spend time analyzing them. This allows for getting your partisans on the side and in some sense avoiding the many more difficult questions, like the entitlement question, which the impeachment Clinton helped scuttle. And so I think that's another reason, I would say, that we've seen this rise of performative politics. It allows people to escape from the really serious issues that we have, serious issues that need to be addressed because of the size of government. At the time of the framers, we really didn't have the same kind of a large state and need for all sorts of detailed decisions of our members of Congress. So I want to end on this point. I don't want to be seen to say that impeachment is wrong. Sometimes impeachments, even if unsuccessful, may have some deterrent effect, and that must be weighed in the calculus. It may well have been right, I think, to impeach Donald Trump for his attempt to overturn the election. And Congress may need to open impeachment inquiries to guide its prudential judgment. But members of Congress would be wise to exercise their discretion against presidential impeachment unless there's a substantial likelihood they can persuade the nation, including many partisans on the other side, that egregious conduct against basic Republican norms warrants removal from office.
Thank you so much, Michael, and thank you, Morgan. It's a cliche of conferences to say that you're honored to be on a distinguished panel. In this particular instance, it's genuinely the case. This is an extraordinary group of people whom I admire and revere, and I'm honored to have a chance to speak alongside them. However, I will say that all of my colleagues came more or less in one form or another to bury impeachment, and I will try, albeit perhaps tepidly, to praise it. In Philip's characteristically elegant formulation, he offered us a kind of elegy for impeachment as a grand inquest with high-minded purpose. Pam said, in also characteristically pointed, analytic, democratic fashion, that partisanship dooms impeachment. And John started with, again, a very characteristic and precise legal analysis of the issues, a formalist legal analysis, and then counseled as a matter of prudence that almost never should there be impeachments, at least not unless you could convince a broad public on the other side. So what do these have in common? I think they have in common a kind of what I would call impeachment formalism. The idea that we have a written constitution, it produced a formal account of, in legal terms, what an impeachment should be for. And we ought to, as faithful agents, albeit with some eye to the development of law over time, carry out impeachment, normatively speaking, when those conditions apply and under the legal procedures provided for it in the Constitution. And when we cannot achieve that end state objective, for example, because of partisanship, we are falling short of what impeachment should be for. Impeachment under those circumstances is doomed. I think I disagree. And here's why I disagree. It's not because I think one can just rely on the apotheme that Philip condemned, namely that, in some sense, impeachment is political rather than legal. Needless to say, impeachment is both. It is a process specified in the Constitution, which is a legal document, and it is simultaneously a process designated to be performed by the political branches of the government. So in that sense, it is also political. And I don't think that Philip would disagree with that formulation. The fact, however, that it is both of those things, both political and legal, puts it in an interesting position with respect to the ideals of the rule of law that we generally hold. And it also puts it in a strange position politically. And last but not least, it puts it in a strange position practically in the real world. So let me just touch on those three elements of strangeness. First, with respect to the rule of law. You know, the rule of law, as we all, I think, understand, is aspirational. In practice, we're not always able to obtain genuine governance by law. And I think this goes all the way back to the aspiration that we be a government of laws and not of men, which is itself an Aristotelian idea, proffered in contrast to the Platonic picture of a philosopher king. But even Aristotle himself had to concede that it's humans who make, apply, and interpret the law. And so, therefore, we'll never entirely escape the human dimension, and therefore political dimensions, in rule of law governance. So there's no avoiding it ultimately, but we aspire to achieve it. And so when we speak normatively in favor of the rule of law, what we're saying is not there is no politics in, say, judicial decisions. We're saying we aspire for there not to be politics in judicial decisions, even though we'll never quite get there, right? So when Justice Breyer goes on the road, as he does every couple of years, to assure us that there's no politics at the Supreme Court, he's performing a civic duty as a now retired priest of our civic faith, of restating the aspiration. He's telling us what we ought to do. And I would prefer to hear him that way than to hear him, as some critics have dismissed him, as somehow naive about what actually happens in the job he was in for 20 plus years. So that's how rule of law operates. Well, in the context of impeachment, we see the gap between the aspiration to following the law as laid down in the Constitution and the political reality much more clearly even than we see it at the Supreme Court, because the participants aren't judges, don't wear robes, really are not very good at making a pretense of acting legally, although they sort of try to in the impeachment proceedings some of the time. They're obviously politicians. They're obviously acting politically. So the falling short of the rule of law that we already sense in all of our legal institutions, say our judicial institutions, is much clearer and much more evident in the context of impeachment. That is an inevitable feature of impeachment and was certainly understood to be so by the framers and has been evident ever since. And indeed, and I'm going to talk about this in just a second, it is also evident in impeachment practice before the creation of the Constitution in England, where impeachment was also framed in the language of the rule of law. Impeachment was presented as a trial, but was also wildly politicized. I would put it this way: impeachment practice in England was extremely shaggy with respect to clearly following rules or rule of law. So that's the first point, that impeachment falls very short of the rule of law typically, and I would say necessarily so, and we view it that way. It doesn't mean we shouldn't aspire for it to be different, and I wasn't lying under oath when I said that, you know, when in the hearing that Pam and I were in, that the members of Congress ought to follow their oaths and therefore ought to follow the rule of law. As a normative matter, I think that's true. But I was saying that with recognition that they are still nevertheless politicians, and in that sense, aren't going to behave fully in accordance with a rule of law ideal. Okay, so what about the question of how impeachment in fact functions today? And the reality that, as Pam pointed out, it's almost impossible in present political circumstances to imagine ever getting a conviction. Well, there, I think, we can simply say that conviction is only one of the objectives that is possible to imagine for impeachment. And other objectives include, we've heard some of them, weakening the sitting president, sending a message of deterrence to future presidents, fulfilling some sense of duty or obligation that we feel to the rule of law system that we know is highly imperfect. That would be another reason. And all of those are very much in play alongside more concrete ones, like trying to intervene to make it more likely that the person will not be reelected, or attempting to communicate a message about the broken nature of our political process. Now, note that all of those objectives are almost impossible to characterize in rule of law terms. In rule of law terms, there's a trial, there are articles of impeachment, which are, we are constantly reminded, analogous to an indictment, and then the outcome is supposed to be the trial followed by a conviction. And yes, the standard is 2/3 of the Senate. But, well, we have unanimity in criminal trials, so it's not unreasonable to imagine such a thing. We talk that way, but that's not an accurate accounting of what impeachment could possibly look like. The politics is baked in because of the body that will do the impeaching and the body that will do the trial. And so no matter how much we aspire to a world where politics mattered less, and that is, in my view, an appropriate aspiration, we have to also keep in mind that these other much more politically definable objectives are legitimate and indeed crucial parts of the impeachment process. So this brings me to my third point, and I'll close with this. I think one could reasonably say in response to what I've just said, well, sure, we concede all of that. But look at how impeachment is being degraded by such things as the impeachment of Secretary Mayorkas, which Philip referred to. If we end up in a world where impeachment becomes regularized and normalized with less and less connection to our high-minded aspirations to define some category of acts as high crimes and misdemeanors, high in the sense of high political, then it won't even be able, impeachment as an institution won't even be able to fulfill the rather modest aspirations that I just assigned to it. It won't even be able to do that because it'll become wholly trivialized. Now, I guess I partly want to concede that that's true. There are institutional practices we associate with political bodies that over time lose their meaning to the point where they are valueless. That can happen. In the history of political science, there are instances of such things. We're not there yet, however, and we're particularly not there in the case of impeachment because the history of impeachment, not only certainly prior to the Constitution, but even after the Constitution, is, I think, seen from an overview perspective, a history of rather modest aspirations that were very specific to particular political circumstances and particular moments where political actors who thought they could gain something through impeachment engage in that impeachment practice. That's certainly true in the shaggy Old English practice, where impeachments, going all the way back to the 14th century, vary from we're very mad at a particular royal designee who's doing a poor job, to we're now really angry about the future of our empire. I'm thinking of the Hastings impeachment, which lasted years and years. To we're angry at the power of the crown in general, and we think we can weaken the power of the crown. These are a wide range of highly politicized and highly specific purposes. And the framers in adopting impeachment, I don't think were naive enough to think, though it wouldn't matter from my theory if they were, but I don't think they were naive enough to think that by importing an impeachment practice, they were turning it into a formalized and precise rule of law system. They may well have thought that about writing down a constitution. That was an innovation that definitely bespoke a certain commitment to formalism and the rule of law. But had they felt that way about impeachment, they would have put it in some other zone, namely before, for example, the courts. They didn't because they understood impeachment to always have this potential for being politicized. And sure enough, in our history, that's exactly how impeachment has operated. Think of the impeachment of Andrew Johnson, which if you view it through the lens of rule of law, is a very difficult set of impeachments to really feel great about, no matter what your partisan political commitments are projected backwards to Reconstruction. I won't go into it, but everyone in the room who cares about impeachment has tried to go into this. We've all done it. And as you get into the details, it becomes really clear that the rule of law standard is not very useful to you. The political meaning of that impeachment could not have been clearer, and it mattered in context. In fact, I think if we push hard, we might think that the only presidential impeachment that has ever happened that was genuinely outside of the context of a highly politicized, specific partisan movement was the Nixon impeachment. And even there, to get to that conclusion, one has to imagine a world that was remarkably enchanted with respect to its ideals of what presidents did. A world that was more enchanted than the 19th century had been, a world where people had forgotten Ulysses S. Grant, a post-World War II world in which network television and elite-controlled newspapers that were not very populist had essentially created a legend or a myth of the president as a kind of Mr. Smith goes to Washington figure. And then that world could be suitably shocked and disenchanted when the tapes were released and everyone understood that the president was capable of criminal activity, not to mention bad language, which reading, I was a little kid, but I was 3, so I don't know exactly what the psychological state of people was, but reading the historical discussions and reading the newspaper reports of the time, it often sounds as though people were equally shocked by both of those things. So under those circumstances of radical disenchantment, maybe we had one moment that became our paradigm case. So if that's our impeachment history and practice in a very tendentious nutshell, I guess I would just conclude that it's okay and acceptable that impeachment has never lived up to the ideals to which it is possible that may be attributed to it. That I myself believe, to be clear, normatively ought to be attributed to it. I want to live in the same world that Philip wants to live in, where we take these things seriously. I want to live in the same world that Pam wants to live in, where we don't have such radical partisanship that it becomes impossible ever to get a conviction. I would, of course, prefer those things. So I'm not making a normative disagreement. I'm saying that in a developmental, gradually evolving constitutional structure, which, as Philip has shown many times in different modes, so he's managed to a lot of people write a masterpiece and then they write it several more times. Philip writes it differently each time. It's still a masterpiece, but it's a different masterpiece each time. The development of our constitutional modes of discourse turns out to follow the development of the underlying structures of our state. And in that developmental process, we make the most of what we have. We have these institutions, we develop them consciously and unconsciously, and we try to put them to our purposes. So seen from that perspective, I don't think impeachment is dead. I don't think impeachment is useless. I think it is salvageable, and I think it will continue to be used. And the fact that it's being used more frequently, to me, is not a reason to think that it's about to collapse and not be useful. It's a reason to think that sophisticated political actors who care about the expenditure of their political resources very much still believe in it and still think it has functions that it can fulfill.
I think to make sure we have time for all of your questions, we'll open it up, and then if you're very silent, I'll fill in. But I have a feeling we'll have great questions from the audience.
I want some time to reply.
Just one quick note to you guys.
Okay.
Sorry, just one quick note to you guys. If you're going to use the mics, please lean in and try to get as close as you can to the mic so we can pick it up and everybody in the room can hear.
Okay. Okay, well, if no one's, we have someone, great. Okay.
Yeah, so thank you so much for the panel. I think that I love a lot what Noah said, so I want to follow up to what you said. Why is this reluctant to talk in pragmatic terms about, for example, I'm going to give you an example. You mentioned Breyer. I'm going to give you John Roberts is the same way. And in the Obamacare case, he redefined what the penalty was to be attacked just to give this aura of we are keeping. So what is this reluctance? The average American voter works for companies that live the same way. They have the policy, and then the policy tends to be aspirational. So the average American voter understands the notion of aspirational policy versus what is this reluctance from the system to admit what it really is?
Yeah, I'll say briefly, we each have roles in this very elaborate performance. And I call this performance the rule of law, and I'm not using the word performance in this sense in a pejorative sense. Pam talked about impeachment becoming a performative gesture. To me, that much of politics is performative gestures, and those are important. Those are constitutive of our politics. So in this performance, the Chief Justice says that we are umpires who call balls and strikes. Recently, one of the justices, it might have been Justice Kavanaugh, was quoted this week of saying, those are the 4 most important words in the Supreme Court's discourse, or something like that. And on one level, that seems like something one should be dismissive of. But I think what he really meant, what I think he really meant was something like, that's our myth. That was a good statement of our myth. So the justices insist on their myth, and that is itself important. The rest of us spend our time, certainly in our profession as law professors, pointing out the ways in which that myth is not true, because that's our role, except on special occasions where we get dressed up and go to Congress, and on those days, we reinforce some variant on that myth in some way, because then we're priests instead of rabbis, So, literally, So I guess what I'm trying to say is, you're right that Americans understand all of this, but Americans, so far at least, have not wanted the system to give up on this aspirational quality. And if you ask why, it might be that we're a naive and simple people who still believe that a written constitution contains the law. That's a possible view. But to my mind, well over 200 years after we put this strange system of written constitutions into place, that's selling us short. I think there's a more sophisticated understanding that a written constitution embodies an aspiration to depoliticize legal decision-making, an aspiration to principle, an aspiration to behave well. And in that sense, people want the aspiration to continue, even as they know that it is an aspiration towards which we will never fully attain, and for which we fall very, 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 very short.
Thanks.
I'm curious how your views of Trump's second impeachment might differ had Mitch McConnell allowed it to go forward before January 20th.
I think that's to you, Phillips.
Okay.
You specifically spoke against it.
I didn't exactly. Our views about the second impeachment with respect to the timing?
Yes. Would your views of that impeachment differ had Mitch McConnell allowed it to go forward before January 20th?
Yes, totally. And
How so?
here I disagree with John. I think the text is perfectly clear. It is so clear that it really risks the foundations of the Constitution generally to ignore. I need your little bicentennial Constitution. So. I'm ashamed to say I don't have.
I'm just glad to see nobody on the panel is like whipping out their Constitution and pretending to be Hugo Black. It just makes me feel better about things.
Or a keel.
Akil.
Or Hugo Black. Oh my God, it's not in there. Michael, where did you find this Constitution?
The text provides, this is saying both who is subject to impeachment and on what grounds. That's separate from the provisions that provide for the House trying them, the House proposing and the Senate trying. I want to say more about that later, about the judicial function, but the text provides, and I quote, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Now, whatever else this means, it seems to me to mean that if you are not a civil officer, then you cannot be removed from office and you cannot be convicted. President Trump, after January 20, was former President Trump. He was no more a civil officer than I am still a Princeton undergraduate. It happens.
Though you may look
on.
like one.
Time moves on. Do you want to come in on this, Mike? Because I know you and I disagree about this.
Yeah, I don't understand this argument. President Trump was impeached on January 13th.
Right.
A week before he left office.
Right.
He was at that time a civil, he was a president, whether that's a civil
Right.
officer is another question, but he was certainly president. And then the Constitution says that the Senate is the sole judge of all impeachments. So he was properly impeached on January 13th. The Senate can try all impeachments. So I don't see why the fact that the Senate didn't begin until after January 20th makes any difference at all.
This is I think, a very subtle, and if I may say so, insidious argument. And the reason I say that is, imagine that one party controls the House, but not the Senate. Imagine that they worry about a president who's running again, a sitting president. So, in other words, I'm saying, imagine the situation we have right now. Suppose a House could impeach that president. They've got the votes. They know he won't be convicted in the Senate, so they simply don't send it to the Senate. They wait. And if that party ever takes hold of the Senate, next year, 2 years, 5 years, 20 years, after he's dead, whenever they want to, they can then take it up again. As a practical matter, it doesn't, to me, make any sense to say he can be validly impeached and therefore he can be validly tried. Think of other situations in which someone can be indicted, for example, if they are in custody. If they escape custody and they can't be tried. It doesn't mean they can't be indicted or re-indicted, but simply because you can be indicted doesn't mean you can be tried and convicted. And what I find disturbing about this is, one, that the passage I read to you is so specific about who is subject to impeachment and conviction and removal. So precise. Whereas the passages on which Michael is relying, that the Senate tries all impeachments, and the House impeaches, say nothing about who is to be impeached or on what grounds. He doesn't look persuaded.
So is it your position that the key date is when the House sends notice of the impeachment over to the Senate?
No, I'm simply saying that if a House were to wait until the very last minute, as the House did, and a president goes out of office, rather than sending it to the Senate, they could just withhold it. And on your theory, as I understand it, because that president had been validly impeached, even though he was no longer president, he could someday be convicted and therefore removed from access to the ballot.
Can I ask a
Is that inconsistent with your view?
No, that is in fact my position. That's
Right.
what the Constitution seems to say. It says the Senate may try all impeachments.
Right. And that passage does not say who can be validly tried and convicted. And that, I'm afraid, is limited to civil officers. Or this is at least my view. And disagreeing with, McConnell and probably Jack disagrees, and Akil, and frankly, every damn person I know doesn't give me confidence.
I think no one wants
Just
to
one
say-
sentence
yeah.
on this. I don't think Michael agrees with this, but there is an answer that Michael could make, though I don't think it's his. I've taken this position and it made a lot of people angry. I don't think the president is impeached under the Constitution until the charge is delivered in the Senate, because historically that's what impeachment was. The moment of impeachment was when a person from the House, originally the House of Commons, appeared at the bar of the House of Lords and declared the impeachment. So on that view, they couldn't do that, for what it's worth. That would be, but I don't think Michael shares that view, so he can't defend this argument on those grounds.
And also, I think you and I may differ on the role of British impeachment as a precedent, but that's another.
Can I ask a question about this, which is, I take it under your view, if the president is impeached and he's being tried and he sees that conviction is about to happen, and he resigns, there's now no way to prevent him from running again.
That's right.
And that doesn't
Well,
worry
no,
you.
wait, hang on now. That's not,
Well, how do you get the disqualification from office?
what is
given-
what's the 18 USC 2583, 2850, you might know the number?
I think you're talking about the insurrection.
Yeah, I mean.
Right, but I'm
what-
just saying, suppose a president is impeached and he goes to
Right.
trial and they've started voting and they get to number 65 and there are a bunch of senators left to vote.
This is the Belknap.
And he just says, I quit.
Yeah, this is the Belknap case.
Then he can't be disqualified from office.
Right. You can't, right. How true.
Doesn't that
The
worry
same
you?
thing is true if he resigns and he kills himself.
Well, if he kills himself, we don't have to worry.
Well, you don't have to worry about it moving to another.
And if he had a sense of shame.
I think the idea that a president impeached in the House, about to be convicted, who's confident he's going to be convicted, can somehow resign and pay no cost. Why don't we break the Constitution to get at him? He might still run for office. Hell, let him run for office. He's disgraced. He's disgraced himself. That he would resign on the verge of being convicted and then present himself or herself for the presidency is not a scenario that worries me. If that's who we're electing, then we're much far gone.
I mean, that's my basic
fear.
problem with where we are right now is who we're electing.
Yeah, but you see, this, if you follow this argument, it reasons from the punishment to the liability. You say, I want this punishment. I want it so badly. I want to protect the country from these cretins. I want to take them, prevent them from the ballot. I don't want the people to have a chance to reelect this vile creature again. And therefore, I've got to imply some way that that person is liable for impeachment. It seems to me that's exactly backwards. Where the text is clear, you have to strictly observe who is liable for impeachment and conviction. And only once that's satisfied can you then say, and these penalties are the ones that apply. But I should immediately say, as I mentioned a few minutes ago, practically everybody I respect disagrees with me. But that was something I said in my talk. Citizens, not the media, not experts, citizens can read these provisions for themselves. And if they are as clear as I think them to be, then it doesn't matter that our emotions and our political sentiments can lead us to overbear them.
Well, I think the disagreement between you and Michael suggests that they're not clear, right? Like it's this, we can't actually find a textual answer to this. You might have a textual answer for impeachment, but I don't see it for conviction in the Senate. And so, I mean, what I'm hearing from you is you put forward a very persuasive sort of purposivist argument for why we should not permit the Senate to sit on an impeachment or the House to sit on sending an impeachment to the Senate. But you rejected various purposivist arguments for the opposite. And so, and I have, one other suggestion about how the Senate could sort of abuse the process if it went the way you're suggesting, which is that the House sends it over on January 13th, let's imagine, and then the Senate delays, the proceedings such that the conviction can't happen until after January 20th, right? So the same thing, right? So
if you had the votes to delay it, what makes you think you wouldn't have the votes for acquittal?
well, that's not really how Congress works. I mean, you could have the votes. You might lack the votes to enact a new AUMF or something, but that doesn't mean that you have the votes to stop a war, for example. I mean, but in any event, there's lots of ways to delay that don't suggest, that don't necessarily give you the votes to acquit. But putting that aside, it seems to me there's all sorts of scenarios in which we have to address the question of, is there some statute of limitations on something, right? Is there a statute of limitations on ratification of constitutional amendments, for example? So that's a different question. The fact that there might be some point at which an impeachment no longer is valid such that the Senate can vote on it, we can discuss a possible statute of limitations without having to mean that there's zero chance for the Senate to vote on something 10 days later. That's just a minor suggestion. It's not a huge point, but it doesn't seem to me that that there's some slam dunk argument to the contrary that we can be found in the text. I mean, as we just saw, these are really just different sort of consequentialist arguments.
Yeah, I sharply disagree. And I'll say why. My argument is not a purposive argument. And it's a textual argument. It's not a prudential argument at all. I validly concede there are all sorts of wonderful reasons to keep Donald Trump off the ballot. Exile him to Mallorca, you know. But the text is so clear, and that, to me, and I hope to you, I hope if you'll read it, you'll see my point. And the point I'm driving at is that what I see as a frightening aspect of impeachment is the degrading of our institutions. The idea that we can treat the Constitution as really just any damn thing we want to get where we want to go. That it is naive to think otherwise. I want to say one thing on a different plane completely about naivete. I had in my notes, I wanted to answer the argument that the framers were not naive. They knew this was a political body they could have sent to the court. This, I think, does not read the history right. And I say it for three reasons. One, we know why they didn't give it to the court. That was proposed. They rejected giving it because they wanted the president to be liable for criminal penalties once he was removed. And they feared the problem of having the same judges rule on his criminal appeals as who impeached and convicted him. That's why, and they're perfectly clear about this. Second, as you know, from 78, Hamilton writes in extenso about how important it is that the Senate, though a political body, can overcome its partisanship, that they can rise to a juridical purpose. That's why the language says try, that's why they take the special oath, and so on. So I don't think it's true that they didn't consider this, but they did, and they rejected it explicitly. The main thing I want to get to is something about it's not cynical, but the knowing look. The idea that we know what's really behind this. Our ideals are really aspirational, but not really operational. Has anybody here seen the movie Secondhand Lion? Well, I strongly urge you to see it. It's a Robert Duvall, Michael Caine vehicle. It's a really beautiful movie. It's about a boy who's foisted off on his great uncles by his irresponsible mother. And these old codgers, they're from Texas like I am, and they do not want this responsibility, believe me. But as you can imagine, they grow fond of the boy. And at one point, the boy asks about something that has been a family legend. And he asks Robert Duvall, is this true? And Robert Duvall says, sometimes the most important things in life can't be determined to be true. I think that's true of legal reasoning. I think the conventions of legal reasoning, like prudentialism or textualism, are not themselves true or false, though they have a true functionality for propositions. And Duvall says that this is true of the most important things. And he gives an example about courage, about honor, about love. He says, it doesn't matter whether these things are true or not. You believe in these things because they're the only things worth believing in. And that kind of belief is much more saturated in public life than I think most of my friends in academic life, or even some who've been in government, believe. I have, like many people who've grown up in politics, very strong preferences among the presidents from Eisenhower on. I worked for several of them. I knew several more. Some I admired a great deal. Some I didn't think belonged in the White House. But every one of them, without exception, until the most recent president preceding President Biden, was patriotic. They were hardworking. I never thought Reagan was a hard worker until I went to the White House and read his personal diaries. With a childish hand. I could give you some other examples of ones I wasn't so admiring of, but without exception, they were people who saw the presidency as somehow elevated from all the compromises they'd made to get where they got. And the most insidious and dangerous thing about what's happening to impeachment is what's happening to our political process generally. That we have become cynical, that we use the law when it serves our purposes, but not if it serves our adversaries' purposes. That the prudential analysis of a constitution is the only one that really matters. So that's my sermon.
Short version of this is 10 comes before 78. The somewhat longer, and I hope only somewhat, is I agree with Professor Feldman in one sense that the framers sought a less politicized constitution, but they primarily did so through the construction of the legislature, the Senate, and the presidency. There's almost very little literature that says the court, that these are the people exercising a certain kind of judgment, will be basically responsible for constitutional development and, for that matter, impeachment. And this is a regime we get with some important modifications for about 100 years. As we get the rise of the court, we get a different notion of what a legislator is, what a president is. And so question number one is, does that affect our understanding of impeachment? As we get polarization, all the features that Professor Karlan talked about, does that affect our understanding of impeachment? Or have we been talking about impeachment as this sort of trans-historic phenomena that is what it is regardless of fundamental changes in what a legislator is, what a senator is, what an executive is, and what the rule of law is?
Well, I'd like to say two things about that. One is that, of course, as our understanding of these different branches and responsibilities changes, we see the Constitution differently. That's the point I began with about the engraving. However, I think it's wrong to say that for the first 150 years or something, the impeachment clause was only applied once. That's not right. A president was only impeached once. But every day of every year, every part of those centuries, the impeachment clause was applied. When you say a provision of a statute doesn't apply, you're applying it. You see what I mean? If a statute says you have to be a citizen of California to vote in a municipal election, and your client comes to you and says, I have dual citizenship. I'm a citizen of California, I'm a citizen of Nevada. I like to live in both places. Can I vote in a municipal election? And you say, no. We don't have dual citizenships in municipal elections, no. I have applied the law, right? It hasn't gotten you where you want to go. It hasn't resulted in your being able to vote, but I've certainly applied it. All those decades when impeachment was not applied to remove people, it was being applied because people were saying, does this rise to the level of impeachment or not? And that's one of the lessons of the John Quincy Adams impeachment about John Connally. But I certainly agree with you that as we change, our activities change. I'm not sure that speaks highly of us recently, but.
Would it be okay just to say a brief word in response just to that last point? I mean, the laws of the Commonwealth of Massachusetts and the city of Cambridge say that if you're in the middle of Harvard Square and the light is red and you cross against the light, there is a procedure whereby the police could arrest you, you could appear before a judge or a magistrate, and a penalty could be assessed. And in that sense, like the impeachment provision, on your account, those laws, it would be fair to say that those laws are always applied. But when you go to Harvard Square, and I've been there on and off for the last 54 years of my life, which is my whole life, I have never once seen that happen. I would be shocked if it had ever been, a procedure had ever been used, and people freely go back and forth as though it were Cairo and as though the red lights just literally had no meaning. So I want some language to describe that, and what I default to is, in the city of Cambridge, the jaywalking laws are not applied. So I'm not saying that that's precisely analogous to the impeachment, but in both cases, what the law does is the law provides a prohibition. In the case of the Constitution, it's a prohibition on high crimes and misdemeanors, a mechanism for its enforcement, and similarly, the ordinary criminal laws provide prohibitions coupled with mechanisms for enforcement and procedures that they go with. So tell me, I'm open to your view, but I want to understand more about what differentiates those cases.
Well, I think the Tyler example is a good one. You know the facts. Tyler was a Democrat. He ran as Harrison's vice president. Harrison was a Whig. Harrison dies, quite unexpectedly. Tyler becomes the first vice president to become president. He immediately turns around and vetoes two important pieces of Whig legislation, just infuriating the Whigs in Congress. And he was already alienated from the Democrats in Congress because it's the party he left. There's a movement to impeach him in the House. John Quincy Adams is the leader of the committee to whom it's referred, thinks he has the votes in the House, but doesn't go on to the Senate because he can't get a conviction in the Senate. Was he applying the impeachment clause? Sure he was. When you don't arrest someone for speeding, you're ignoring the law. When you don't arrest the undergraduate who jaywalks, you're a policeman anyway. I don't think we have civilian arrest in Boston. You're not applying the law for some reason. For a reason. Everybody does it. Nobody obeys it. My parents had a friend who was in Rio for a holiday, and she rented a car. She came to the bottom of a hill, and a truck smashed into the back of her. The truck driver gets out, runs around to the door, and says, "You fool, don't you know no one stops at that stop sign?" You know, there are customary methods of assuming that if it says 65, you can go 70. If it says 70, you can go 75. That's part of the, call it the common law of statutory law. So but it doesn't mean it's not applied.
But it seems to me that what we're having a discussion about, if we bring it back to impeachment, is when should there be prosecutorial discretion not to proceed on an impeachment where you're convinced that the target of the impeachment has engaged in high crimes and misdemeanors. And what John says is, don't do it if you think it will make society worse off. And I think that's what Noah is saying in a slightly different way. And I'm not sure what you're saying about that.
I'm prepared to give discretion to the House managers, for them to say, we don't want to do this because, John's saying it will divide the nation and polarize it. We don't want to do this because we don't want to remove from the ballot. We want the public to decide. We don't want to do it because he can't get a conviction in the Senate. And prosecutors all the time will decline to prosecute, no matter how guilty they think the party may be, if they think they can't get a conviction in a jury. I'm prepared to build that in. What I am not prepared to do is to override the explicit text because of some prudential reason. And I think we do ourselves, particularly people as idealistic as Noah, for heaven's sakes, we do ourselves a disservice when we think that these political actors are stating values for the public they themselves do not believe in. That just hasn't been my experience. I've seen political life at all its levels, And I've seen people sacrifice their lives, their families, their wealth, their peace of mind
Can I
to
ask,
try to do something for the common good.
can I take chair's prerogative? Because I think we have one last time, so I can ask. So you've all mentioned a lot of reasons you think that impeachments are increasing, or possibly increasing, given the small n, that are political. I don't think you've mentioned the incentives of the party bringing the impeachment. I mean, because there's this puzzle that really, Philip, you mentioned, Clinton's popularity goes up during his impeachment a lot. And actually, Trump doesn't seem to be hurt as much as you'd think by his 2 impeachments with his own party and in the general, if you believe any of the polls now. But the parties aren't stupid who are politically, at least, who are bringing these impeachments. So they're doing it for some reason, despite this, right? And it seems like it's for their own, these are being brought for their own supporters to either raise money, to sort of respond to the, so I'm just wondering, do you agree? I know you all disagree about a lot, so do you agree with that? Do you disagree? And if that's the root cause of what's bringing them, how do we solve that? Because that seems like it's not just driven by the problems of the other party, it's driven from the within-party motives.
So let me take a crack at it, and I want you to have the last word. In the Clinton impeachment, I think the idea was that he would be tarnished, that, and it would divert his work. President Clinton is a highly intelligent man. He's a very hard worker, but it did divert his work. I was working.
Yeah. No, it did divert his work. He wasn't tarnished as much, but
really
it
changed.
diverted it.
And I think that the speaker thought, maybe I'll get the votes, maybe I won't. I'll roll the dice and see, but I'm going to mess up his hair in the meantime.
I don't think they thought they'd get him. I'm going to disagree, but I think they thought they'd tarnish him, and they misjudged on that. But the Democrats anyways, yeah.
I just would say briefly that I think all people, are capable of holding multiple ideas in their minds simultaneously about important things. And so I don't mean in any way to discredit the genuine sincerity of many real public servants, including elected officials. I don't mean to discredit that at all. I think they, for sure, in an important part of their psychological makeup, believe in the aspirational ideals that I'm talking about. I think, though, that when you ask them to put on a slightly different hat and say, well, what will gain me political advantage here? They are very comfortable in private and even sometimes increasingly in public, revealing those motivations in pretty explicit terms. And when you evaluate the motivations that they're then expressing, they don't sound so aspirational. They sound partisan political. And we all of us in our conversations in and out of government have heard many conversations that partake of either of those things. And people can move in and out of those two modes in a few seconds of one another. So that's all I'm trying to say. And when I talk about the overarching issue, which is the relationship between the rule of law as an aspiration, that is to say, the rule of law as an aspiration for judicial, say, decision-making, totally removed from party politics and maybe even from political ideology. Maybe not, that's not supposed to be part of the aspiration, but there's disagreement about that, I recognize. But for some forms, it would be including even that aspiration. All I'm saying is, when we put on our realist hats, we know that such considerations do come into play. In the market state that you describe, where there are polls for everything, even the justices of the Supreme Court are, to a certain extent, following the election returns. And if Mr. Dooley is to be believed, they were even doing that before there were polls, and when we were just entering our peak as an imperial state. So that's just a description of psychological reality. I feel very comfortable in offering the accuracy of that claim for anybody's evaluation. Then there's the separate normative question, which is what are we to make of the fact that this is how humans are, that they have aspirations, and then the same people are capable of offering a completely pragmatic, realist, instrumental account of the same set of actions. And my normative response to that is to embrace that reality and say that we ought to continue to maintain those aspirations without pretending that the other side is not also in play. And that, holding those two things in mind simultaneously to me, is what legal liberalism, if you want to call it that, or constitutional democracy, or the rule of law, I don't care which phrase you use, that's what it consists of. Because otherwise, It consists of standing up in public and insisting on things that we know are not fully the case. And I don't want it to be that. I don't want it to be a hypocritical practice. I want it to be an honest practice where when we're speaking